Good evening, friends. I, on behalf of Beyond Law CLC, welcome you all in the series of webinars. But the interesting facet for today is, while we are holding a series of webinars, here is a series of the insights to the motor accidents claim. And today is the part 2, wherein Mr. Srinivasa Raghavan, who has been giving insights as told earlier, that is on the first part, that we will take up the different parts within the meaning of the motor accident claims and what are the nuances of negligence. Mr. S. Srinivasa Raghavan, as such, needs no introduction on this platform because these series are being done in collaboration with SSR. And those who have been following him up, he has his own YouTube channel wherein different speakers of immense knowledge are coming, just like where we have Mr. Srinivasa Raghavan to give the insights on a topic which a common man, a student, and a lawyer, as well as the insurance companies, are quite keen to understand. While accidents are one of the major sources of deaths as well as accidents on roads, but what are the nuances of negligence and what could be the way forward? As a lawyer to understand, we requested Mr. Srinivasa Raghavan to give the insights. In fact, this becomes his third, I would say, lecture on the motor accidents claims itself. Though this is divided into a series of that so that one can understand which such topics while you are practicing in the district courts or in the high court wherein the FAOs are filed, do come in. Mr. Raghavan has a passion for teaching as well as writing, but above all, as an advocate, he takes the challenges as a lawyer also. He has been taking and teaching classes in the National Judicial Academy Bhopal and Tamil Nadu Judicial Academy Chennai and its regional center. Though it's a different facet that because of these testing times, he would not be able to go to Bhopal. And somebody's loss is the gain of the other persons who could gain through the virtual platform. Though for that purpose, we would not like to say that these lockdowns should continue so that we can have this knowledge sharing by him through a virtual platform. Now, since we have been requesting him, even when the times become better, he would definitely come and share his knowledge in different perspective law. It's not that he simpliciter gives knowledge on motor accidents. He has also given on the Hindu Succession Act, the latest judgment. And that session on the YouTube of Beyond Law CLC is doing exceptionally well. And these sessions on the motor accidents are also doing extremely well. Without taking much time, since we all know that the courts have started in large number of places, even the physical courts have started. I understand there has to be a balance between the learning as well as at the same time of going ahead with the professional commitments. So I request Mr. Raghavan to straight away to take us to the deeper insights of the nuances of negligence. Over to you, sir, and thank you for accepting our invite.
Namaste, Vikas, Sab, and good afternoon to all the participants. I'm very extremely happy to be part of this knowledge sharing platform, and today being the second session on the series of lecture on the subject of motor accident claims. This concept of negligence assumes greater significance in the sense that unless the issue of negligence is addressed by the courts, there can be no proper adjudication of the dispute in toto. In other words, negligence is the first ingredient to be satisfied by the claimants, and it is the first and foremost issue to be framed by the tribunals, and the first and foremost finding to be by the tribunal before giving the quantum of compensation. So I have just framed the deliberation in such a simple way that I'm just going to give an insight about what exactly is meant by negligence in the shortest form, and 3 or 4 different subtopics about negligence, and the different phases of negligence and the aspects in which it can be dealt with. So as you are all known, negligence is not defined by the MB Act, and we are going to go for either common law principles, or we'll have to go for either Hasbury's Laws of England or any other law of torts. But anyhow, there are plethora of judgments which are in the nature of explaining or defining what exactly is meant by negligence. So today's scheme of the lecture will be in the form of definition of negligence, description of type of negligence, and various facets of negligence. So when we go to the definition of negligence, I would like to cite 2 important judgments of the Supreme Court of India, where the Supreme Court has dealt with the nuances of the issue of negligence. Number 1 is the landmark judgment. We all know, though it is pretty older, it's still holding the field. That is being Corporation of Greater Bombay versus Lakshman Iyer, reported in AIR 2003, Supreme Court, page 4182. And the second case being MS Griwal versus Deep Chand Sood, MS Griwal versus Deep Chand Sood, reported in 2001 8 SEC, page 151. 2001 8 SEC, page 151. I promise Vikas and others that at the end of the session, I'll just share the citation in your drawbacks, and Mr. Vikas will share with you in the WhatsApp group. So when we go to the question of negligence, one more judgment is also relevant. It is reported in 2014, 3 SEC, page 590. Reported in 2014, volume 3, SEC 590, in a case between Pawan Kumar versus Hari Krishna Das and others. So when we go to the definition of negligence, I would rather say simply, negligence is a breach of duty or a lack of proper care in doing something. This is saying in the what is called active or direct or positive way. Negligence is a breach of duty or lack of proper care in doing something. It can be also said in the negative. It is want of attention and doing of something which a prudent and reasonable man would not do. These 2 are the commonest definition of negligence. I repeat once again, negligence is a breach of duty or lack of proper care in doing something. It is also want of attention and doing of something which a prudent and reasonable man would not do. Negligence also means more than carelessness. Negligence does not amount to mere carelessness. It has got something more than what is called a carelessness. It is a conduct, a result of both omission and commission. At times, omission also amounts to negligence. At times, commission also amounts to negligence. We'll come to it a little bit later with the help of case laws. In Municipal Corporation versus Lakshman Iyer, in AR 2003 Supreme Court 4182, the Supreme Court has gone in the minutest details of what is called definition, what is the definition of negligence, and what is called negligence implicitor or per se, and what is called contributory negligence, and what is called composite negligence. These 3 elements of negligence are dealt with by minutest detail by the Supreme Court in the said case law. I may request my participant friends to go through when you have enough time. What constitutes negligence is the question that is looming large in the mind of a lot of persons. The answer for the question, what constitutes negligence, it varies under different conditions. In determining whether negligence exists in a particular case or not, whether an act or omission or commission amounts to negligence or not, all the attending and the surrounding facts and circumstances have to be considered. This is more important. Negligence cannot be so easily singled out and defined and found out unless we take into stock the attending and surrounding circumstances and facts. This is the principle enunciated by the Supreme Court in Pavan Kumar's case, reported in 2004 3 SEC, page 590. Now, after defining or understanding the basic ingredient of what is called a negligence, let me now elucidate what exactly is the scheme of the deliberation of the day. Negligence may be classified into 4 major categories for the sake of convenience and for the sake of pleading. We have got negligence per se or negligence implicitor. We have got contributory negligence. We have got composite negligence. And we have got finally what is called self-negligence. When we speak of negligence per se or negligence implicitor, it means in a claim petition, we allege that the driver of the vehicle that dashed against me on my vehicle, what we call as a colliding vehicle, he is negligent. That is called negligence implicitor or negligence per se, where there is no element of contribution, there is no element of involvement of any other vehicle, there is no element of self-negligence. If we say that the colliding vehicle is fully responsible for the accident, it is called negligence implicitor or negligence per se. And we have got phases of negligence which I am going to deal with in this deliberation. I will just give the broad heads under which I am going to deal with. Negligence in terms of drunken driving, in the sense that either the victim is drunken or the driver of the vehicle is drunken, inebriated mood. Drunken driving, overloading. For example, 3 adult persons traveling in 2-wheelers. Then a minor who is disqualified to drive a vehicle, driving a vehicle. Then driving a vehicle without wearing a headgear or helmet. Then carrying explosives in public service vehicle. Then bursting of tires or poor maintenance of vehicle, that is also a part of negligence. Then murder happening in the course of what is called accident or in the public place. Then hitting from behind or parking the vehicle in the high road. Then what is the duty of the driver and conductor in the public service vehicle when the passenger is either getting down or alighting the vehicle? Then projecting arms or elbow over the window of the public service vehicle, footboard traveling, and in case of goods carrier, sitting atop the goods. This can be the various facets of what is called negligence on the part of the victims of the road accident, and at times on the part of the driver of the insured vehicle. Then we have already defined or told about 4 types of negligence. Number 1 is negligence implicitor. When we go to the definition of negligence implicitor, as I already told, it is either a commission of something or omission of something which resulted in the particular incident of accident. The question is, what is the burden of proof in case of a claim petition filed under section 166 of the NV Act? We all know there are 3 enabling provisions as of now in the Motor Vehicles Act, section 140, section 166, and section 163A. In a claim petition under section 140, negligence cannot be even raised. As per the judgment of Supreme Court of India in the Sunil Kumar case on reference, negligence cannot be defended, cannot be placed as a defense by the insurance company or the owner. So the only provision of law in the MV Act where the question of negligence assumes importance or requires proof and pleading is section 166 of the MV Act. Here, the burden of proof lies on the claimant. So the claimant is duty bound to prove that the negligence in causing the accident was solely on the part of the driver of the respondent whose vehicle caused the accident, out of which he suffered injury or the death happened. The judgment ruling the roost in a claim petition under section 166, where the element of negligence is discussed at length by the Supreme Court, is a classic case called Minu B. Mehta. Minu B. Mehta versus Balakrishna Ramachandra Nayan, reported in as early as in 1977. 1977, volume 2, SEC, page 441, is the case law between Minu B. Mehta and Balakrishna Ramachandra Nayan, where the Supreme Court has discussed at length in a claim under section 166, the claimant has to plead and establish that he was not at fault, there was no negligence on his part, and the negligence was solely on the part of the driver of the colliding vehicle. Then we've got one more case law called Oriental Insurance Company versus Prem Lata Shukla. This judgment will be recurring again and again in lot of aspects of negligence. Oriental Insurance Company versus Prem Lata Shukla, reported in 2007, volume 13, SEC, page 476. 2007, volume 13, SEC, page 476. And here the Supreme Court has also discussed the requirement of proof of negligence by a claimant in a claim petition under section 166 of the Motor Vehicles Act. Now the question is, what kind of evidence is required in a claim under section 166? We know very well that the drivers are prosecuted if they commit an accident before the judicial magistrate under various sections depending upon the gravity of offense and the result of the accident. Whether strict proof of evidence, as in the case of a criminal trial, is required, or any other lesser mode of evidence is required, is answered by the Supreme Court in a case called Kusumlata versus Sadbir. Kusumlata versus Sadbir, reported in 2011, volume 3, SEC, page 646. As Vikas sir has already requested, this time I'm citing only Supreme Court cases judgment so that the participant need not reported in 2011, 3 SEC, page 646, where the Supreme Court has held that strict proof of evidence, as in the case of criminal trial, is not required in a case under the Motor Vehicles Act. It is only the preponderance of probability that is the hallmark of evidence. It is a summary procedure. There is no question of going for strict proof of evidence as contemplated by the Evidence Act in a criminal trial. Then next dimension of negligence is common in case of public service vehicle. For example, we take a bus. A bus is supposed to carry only passengers and only permitted kinds of goods, personal belongings, etc. In case if the bus driver or conductor permitted any one of the passenger to carry something which is an explosive substance, whether it amounts to negligence on the part of the driver or the owner of the bus or the conductor, is answered by the Madras High Court recently. That may not be finding a place in other journals. It's a case between Sri Jayaram Roadways versus National Insurance Company, reported in 2018, volume 1, Tamil Nadu Motor Accident Cases, TNMAC, page 90. This is a case very pathetic where two persons were carrying gelatin sticks in a sack, gunny sack bag, and in a crowded bus, they were permitted by the conductor and the owner of the, I think, driver of the bus, to place the gunny bag on the engine of the bus. You know well, a gelatin stick is easily inflammable, and at one point of time when the engine got highly heated up, the cabin of the engine got heated up, and somehow a spark came, something happened, and the gelatin sticks got exploded, and the driver was suddenly in a what is called unexpected shocking mode. He has driven the vehicle haphazard and capsized the vehicle. The vehicle got fire and it got capsized into a nearby gutter, causing death of lot of people and injuries to a lot of people. Here, the case went up to the High Court, where the tribunal was pleased to hold that the owner was personally not present in the vehicle. So the driver and conductor cannot be held responsible for permitting the passenger to carry the explosives. And finally, the insurance company was made liable. And there was not even a direction for pay and recovery or something the insurance company expected. The matter went to the Madras High Court Madurai bench. The Madurai bench, after holding an elaborate inquiry, held that the act of the conductor and the act of the driver of the bus to permit gelatin sticks in a gunny bag to be carried in a passenger vehicle is an act of negligence. The physical presence of the owner is not required because the driver and conductor are the servants of the master being the owner. So by holding that the act of permitting explosives to be carried in a public service vehicle being a classic case of example of negligence, the Madras High Court has held that the insurance company is primarily liable at the first instance, and holding it is a permit violation also directed direction for payment and recovery. It is there in 2018 volume 1 TNMAC page 1, where the High Court has held that a passenger who is permitted to carry explosives in a public service vehicle, in such an event, the owner is liable for negligence. Then there are actions where we have heard recently. The principal of the Madurai Law College, he met with an accident and he died in a road accident. While he was driving the vehicle, the front tire of the car got busted and the vehicle ran on the other side of the road and dashed against a tamarind tree or something, and he died on the spot. The question is whether such things would amount to negligence. The Supreme Court said yes in the case reported in 2001 volume 2 SEC page 9. 2001 volume 2 SEC page 9, in a case between Kaushanama Begum versus New India Assurance Company. Kaushanama Begum versus New India Assurance. Here, the Supreme Court has held that causing an accident by using a tire which is old with all the wear and tear amounts to negligence. So if the owner of the vehicle he's got a duty to maintain the vehicle in the Pakka condition. That is the purpose of getting fitness certificate. If the owner of the vehicle fails or omits to maintain the vehicle in the proper way, including the tires, in such a case, the Supreme Court held that it is a classic act of negligence. Kaushanama Begum versus New India Assurance Company, reported in 2001, volume 2 SEC, page 9. Then we will have to go for the central motor vehicle rules and the provisions of the Motor Vehicles Act for the purpose of deciding what is the degree of negligence in case of drunken driving. So the drunken driving is of two different categories. Either the victim of the road accident who was a pedestrian or a person who was riding a vehicle might have been in an inebriated mood, or he was under the influence of alcohol having consumed it, or the driver of the bus who caused the accident might have been drunken. In such cases, it is the Madras High Court that takes the best lead in the entire country. Justice Kribagaran, who is known for his proactive judgments in motor accident jurisprudence, has given a judgment in two important cases. In one case, he has taken a suyamoto cognizance of the drunken driving and has directed the police to take severe action by citing Section 185, Section 184, Section 202 and 203 of the Motor Vehicles Act, read with Rule 19F of the, Section 19F of the MV Act, and also Rule 21 of the Central Motor Vehicle Rules, where the Madras High Court has issued a slew of directions. In a case reported in Tamil Nadu Journal, 2020, Volume 1, Tamil Nadu Motor Accident Cases 449, 2020, Volume 1, TNMAC, page 449. This has not been reported in the ACJ. So persons who are not in a position to go through the Tamil Nadu cases are requested to subscribe or read one online journal called CDJ, Complete Digital Judgments, where the judgments of all the high courts of the entire country, all the extrajudicial courts and tribunals, all the consumer courts and the Supreme Court of India are reported the very next day. So where you can find this judgment. 2021 TNMAC page 49, and in the matter of drunken driving versus Chief Secretary of Government of Tamil Nadu by Justice Kribakaran, once again reported again in 2009 volume 1 TNMAC page 626. CDJ, Complete Digital Judgments, is the name of the site or the online journal, Complete Digital Judgments. So the relevant provisions are cited by the Madras High Court. The Madras High Court has issued a slew of direction to police people how to handle this kind of menace of drunken driving. So I could come across one case law where I'm sorry to say that an insurance company has taken a strange defense. In that case, the driver of the vehicle that is insured with the particular insurance company was under the influence of alcohol. The insurance company has taken a plea that they are not liable because the driver of their own insured was under the influence of alcohol. There can be no rubbish defense than this one. The fact that the driver of the insured vehicle was permitted to drive the vehicle under the influence of alcohol per se amounts to negligence. No further proof is required. So whenever the FIR states that the driver of the vehicle was under influence of alcohol, the courts are duty bound to find that the driver was fully or wholly negligent. The dispute may come only when the victim was under the influence of alcohol. It may be a case of a contributory negligence. So this is the drunken driving aspect of negligence. 2021 TANMAC page 449. 2009 1 TANMAC page 626 are the classic judgments of Madras High Court regarding the menace of drunken driving, how to control and manage these kind of things. Then, what about the punishment which the police are supposed to take against the drivers? The Supreme Court has seized the matter, and in a case between State versus Sanjeev Nanda, State versus Sanjeev Nanda, reported in 2012, volume 8 SEC, page 450, the Supreme Court said that we need a deterrent punishment for drivers who drive the vehicle under the influence of alcohol. Then again, in the same case, the Supreme Court held that the burden of proof of drunken driving is not an ordinary thing. I could find in some cases the police would have written or the doctor would have written in the admissions action register that there was a smell of alcohol, or the viscera report or the postmortem report would say that there was some liquid similar to alcohol in the intestine. These things are not sufficient to prove the element of drunken driving. The Supreme Court has very clearly held in Sanjeev Nanda's case that the driver should have been subjected to medical evidence, and there is a rule in the Center Motor Vehicle Rules which says that so and so gram of alcohol should have been contained in so much of milliliter of blood. Unless that ingredient is satisfied, there can be no drunken driving. This is what the Supreme Court held in a case of Sanjeev Nanda's case. Again, now the doubt rises, if the driver is found to be drunken, whether he can be prosecuted only under the Motor Vehicles Act or under the IPC or under the board. The judgment of the Supreme Court, I am not able to find whether it is reported or not. In CMA, appeal against CMA number 906 of 2010, dated 4/10/2019, between State of Arunachal Pradesh versus Ramachandra Ravidas. I'll try to find the judgment and share with Mr. Vikas, where the Supreme Court has held that prosecution for drunken driving lies both under the ambit of the Motor Vehicles Act and IPC. It is not confined only to the Indian Penal Code. This is what is the first aspect of negligence implicitor or negligence per se. Let us move to what is called contributory negligence. Contributory negligence means failure by a person to use reasonable care for the safety of either himself or of his property. For example, I drive a vehicle and there is a collision of my vehicle and another vehicle. There are chances that I also would have contributed to the accident by my own negligence, and other side would have also contributed. In such a case, it is called contributory negligence. The injured claimant or the victim has contributed to the accident. It is called contributory negligence. It is more clearly defined by the Supreme Court in a case called Pramod Kumar, reported in 2002, volume 6 SCC, page 455. 2002, volume 6 SCC, page 455, where the Supreme Court has clearly held that if a person fails to take reasonable care while riding the vehicle of his own personal safety and his damage to his own vehicle and part of the accident, he is called a contributor to the accident, and what is called a contributory negligence. The question of contributory negligence would arise only when both parties are found to be negligent. In a case of contributory negligence, there can be no finding that only one person is negligent. Contributory negligence presupposes that the tribunal must find that both the drivers are negligent. The contribution apportionment may be different. It may be 10:90%, or it may be 20:80, or it may be 70:30. It all depends the evidentiary value. So contributory negligence means both the drivers are both the victim and the driver of the insured vehicle are equally contributory negligent, and there can be no finding that only one person is negligent. This is explained in a case called T.O. Anthony versus Carr Vernon by the Supreme Court, reported in 2008, volume 3 SEC, page 748. 2008, volume 3 SEC, page 748. This is a classic case for what is called composite negligence, and whether the claimant has got a right to sue against individual, any one company or everybody. In this case, the Supreme Court has held what is called contributor negligence and has clearly ruled that when the tribunal finds that the claimant is guilty of contributor negligence or the victim is guilty of contributor negligence, there should be a commensurable reduction of quantum of compensation. For example, the tribunal finds that the victim of the road accident contributed to the accident, for example, to say that to the extent of 30%. So 30% is apportioned on the part of the deceased or the injured, and 70% is apportioned on the part of the colliding vehicle. Means in the event of compensation being 10 lakhs, 3 lakhs, that is the 30% of 10 lakhs, should be reduced, and the claimant will be given only rupees 7 lakhs as the compensation. It is given by the Supreme Court in T.O. Anthony versus Carr Vernon, reported in 2008, 3 SEC, page 748. Next question is, for example, for some reason, there are some parents who are very much fond of their kids, irrespective of the age of the kids, for about 15 years, 14 years, they permit their kids to drive or ride a vehicle. I could see persons of the year of 14 or 13 riding scooters and motorcycles very easily on the roads, and minors riding cars also. And in that case, whether it amounts to negligence, for the simple reason that the minor drives a vehicle, can there be an element of contributor negligence? This matter came before the Supreme Court in a case reported in 2014, 4 SEC, page 511, where the Supreme Court states, for the simple reason that a minor who drives a vehicle, who is not competent to hold the driving license, drives a vehicle and the accident happened. The Supreme Court says, please see one thing. Unless there is a proof that the accident took place on account of negligence on the part of the minor, simply because he happened to be a minor, there can be no finding of contributor negligence. In other words, simply because the minor drives the vehicle without a driving license, there can be no automatic finding of contributor negligence. There should be a finding that the minor by his negligence also contributed. That is why he is contributory negligent, and simply because he is minor, there can be no automatic contributory negligence. This is given in 2004-14, volume 4 SEC, page 511. A participant has raised a question once again. What is the difference between composite negligence and contributory negligence? Please wait. After finishing composite negligence, I'll come to the distinction. Next question is very important, that is ruling the roost in the entire country, and Tamil Nadu once again being the forerunner. There were protests by the Bar Association, and the Bar Association fought against the judge who passed the order, and finally that paved way for security for the high courts in Madras and Madurai because of protests by some of the advocates. It is called helmet. I would say if you don't wear the helmet, you are going to meet the hell. Headgear. Whether persons who are by law mandated to wear helmet omits or fails to wear helmet, can there be a finding of contributory negligence? For example, a two-wheeler is driven by a person and there is an accident, he falls down. Had he worn the headgear and had he suffered a head injury, the helmet makes all the difference. He wouldn't be in a position to meet the hell. So there are a lot of judgments where the Tamil Nadu High Court has taken a lead stating that if the rider of the vehicle who is the victim omitted or failed to wear the headgear, there must be an automatic inference of contributory negligence to the extent of 15%. The court says there should be a contribution of 15%. Here, there is a judgment of the Division Bench of Madras High Court. Again, you may search in CDJ or some other ACJ or something between R. Mallika versus A. Babu. I would say this is one of the best judgment on helmet by once again Justice N. Kribakaran, who has given a judgment in this case stating that not wearing helmet or headgear would certainly amount to contributory negligence. I think the advocates who are defending the claim on the other state may also take this judgment to the knowledge of their respective judges in the interest of the claimants. There must be an awareness. There must be a campaign that helmet wearing must be made mandatory, because who is going to die is the breadwinner. Or death, leave alone the death. If he is met with a head injury, the complication will be disastrous, and he may be a person with paraplegia or hemiplegia that may be a burden for the family. So the Madras High Court has also cited Section 206 of the Motor Vehicles Act and 126 there also for the purpose of recommending stringent action against such a person who do not wear helmet. Then, footboard. If a person travels in the footboard of a bus and the bus just runs over a speed breaker, or the driver in a position to avoid accident suddenly applies the brake, something happens, there is chances for the footboard traveler to fall outside the vehicle and meet with an accident. Here, there are judgment to say that footboard traveling is forbidden. So anybody who travels in the footboard is guilty of contributory negligence. Judgment reported is 2015 4 CTC, page 644. 2015 4 CTC, page 644. Again, the judgment of the Madras High Court in 2002, volume 6 CTC 455. 2002, volume 6 CTC 455, where there must be an element of reduction of compensation in case of footboard travel. Then the question is, very interesting question is, two persons traveling in a two-wheeler is the normal norm. When three persons, especially three adult persons, we see normally in the road very easily, three adult persons traveling in two-wheeler, what is the law? The issue is simply because three adult persons traveled in a two-wheeler, there can be no automatic inference of contributory negligence. Once again, as in the case of a minor driving a vehicle, the tribunal must come to the conclusion that only because of the fact that 3 adult persons traveled in two-wheeler, there was a balance loss, or because of the negligence on the part of the rider of the two-wheeler, which is attributable to 3 persons who ride a two-wheeler, there can be no automatic inference. This is the judgment of Supreme Court. The Supreme Court said there must be a causal connection between the travel and the accident. This is reported in 2018, Volume 1, TNMAC 745, equivalent citation, 2018, Volume 6, SEC, page 765. 2018, Volume 6, SEC 765, in a case between Nishan Singh versus Oriental Insurance. Nishan, N-I-S-H-A-N. Nishan Singh versus Oriental Insurance. And the judgment is also regarding a case of contributed negligence by vehicle parked in the road. And I'm sorry, participants, the judgment regarding 2 persons and 3 persons in two-wheeler is reported in Mohammed Siddiq versus National Insurance Company. I'm sorry, that is not Nishan Singh. I'll give the citation to Mr. Vikas later. It is Mohammed Siddiq versus National Insurance Company, where the Supreme Court has held that the 3 persons in two-wheeler need not automatically result in contributed negligence. The judgment by Justice V. Ramasubramaniam from Madras, and the judgment of Nishan Singh is a judgment on parked vehicle in the roadside. Parking the vehicle in the main road or roadside without indicators or reflector has been a nuisance or menace for a lot of accidents in the highways. The judgment of Supreme Court in Nishan Singh, reported in 2018 6 SEC, page 765, is very clear that a vehicle which comes in the night hours and dashes from the behind of a stationary vehicle need not be an element of contributed negligence. In the event of daytime, or in the event of reflectors are being placed or indicators are switched on, there may be a case of contributory negligence by the two-wheeler rider. But when the lorry or some other vehicle is parked on the roadside without reflectors and indicators, there can be no element of contributory negligence as per judgment of Supreme Court of India in Nishan Singh's case. Another case where a similar view is taken by the Supreme Court is Jumani Begum versus Ram Narayan. I got only a Tamil Nadu judgment, 2020, Volume 2, TNMAC, page 74. 2020, Volume 2, TNMAC, page 74, where the Supreme Court has held that a parked vehicle in the roadside without indicators and reflectors has to be found fault entirely in the absence of proof that they have taken care. This is what is called a contributory negligence. Let me move to what is called a composite negligence. This is the area where most of the judicial officer or most of the advocates confuse themselves, or they are not in a position to appreciate what is called a composite negligence. In simple terms, I would say composite negligence is defined where an injury, either personal injury or a fatal injury, is caused by the wrongful act of 2 or more parties, and the victim is not bound to see a strict analysis of a proximate or immediate cause of the event to find out who can be sued. For example, the bus is driven by a driver rashly and negligently. One more bus coming in the opposite direction. The driver also rash and negligent. If both the vehicles collide, and I am not the driver of any of the vehicles, I am only a passenger of any one of the vehicles, that these 2 drivers have contributed to the accident, it is called a composite negligence. The question posed to me by one participant is, what is the distinction between contributory negligence and composite negligence? Contributory negligence is a negligence where the victim of the accident himself contributes to the accident. In the said example, I would use the example called vehicle A and vehicle B. When the vehicle A and B collides and both are liable for the accident, for the driver of vehicle A or for the driver of vehicle B, it is a contributory negligence because he drives the vehicle, he caused the accident. In the same example, if a passenger who travels in vehicle A or vehicle B is injured, for him it is called composite negligence. For contributory negligence, one vehicle is enough. A pedestrian may also contribute if he crosses the road all of a sudden. A person may contribute to the accident if he runs in the road or walks in the road in an influence of alcohol. But in composite negligence, there must be at least two vehicles, minimum two vehicles, and two vehicles collide, and the passenger in any one of the vehicle can accuse both the vehicles of composite negligence. So in contributory negligence, there need not be two vehicles. In composite negligence, there must be at least two vehicles. In contributory negligence, the victim himself has contributed to the accident to some extent, where in composite negligence, the victim is not at all at fault. It was the fault of the drivers of the two or three vehicles. So the composite negligence refers to negligence on the part of two or more persons, where a person is injured or dead as a result of negligence on the part of two or more wrongdoers and not by himself. It is said to be the person is injured or dead on account of composite negligence. This definition of composite negligence is elaborately and elucidated by the Supreme Court in a case called T.O. Anthony versus Carvernon. I already told you, reported in 2008, volume 3 SEC, page 748. And there is one more case of Supreme Court called Andhra Pradesh SRTC, Andhra Pradesh State Road Transport Corporation versus K. Hemalata, reported in 2008, volume 6 SEC, page 767. Now, the question is, in case of composite negligence, there are two or more three vehicles, whether the claimant is bound to file the claim petition against all the companies or any option is given to him to sue only one of the companies. The Supreme Court has been holding time and again that the option is given to the claimant. For example, vehicle A, vehicle B, and vehicle C, three collide with each other and an accident takes place, and some of them died and some of them injured. It may be a passenger in vehicle A, he may be a passenger in vehicle B or in vehicle C. Any passenger in any one of the vehicle has got an option to sue any one of the or any two of the all the three of the vehicles. It is his choice. For example, if a passenger in vehicle A is injured, in a case of composite negligence, he may file the claim petition against the driver of vehicle A only. He need not implead vehicle B and vehicle C because the liability in composite negligence is always joint and several. The Supreme Court has held in T.O. Anthony versus Carvernon and a recent case called Kenyai, Khenoi versus New India Assurance, reported in 2015, volume 9 SEC, page 273, as follows. In the case of composite negligence, negligence of two or more drivers, they are joint wrongdoers. Their liability is joint and several. In such cases, determination of inter se liability or apportionment of compensation or implement of all joint wrongdoers are not necessary. Entire compensation can be awarded against sole wrongdoer. Inter se liability of joint wrongdoers is to be worked out separately. The claimant has the option to sue any one of them. For example, in the set example, if vehicle A, B, and C are collided with each other, and the passenger in vehicle A sues vehicle A only, the owner and insurance company of vehicle A has to make the entire compensation to the claimant, and vehicle A owner or the insurance company of vehicle A can recover the compensation as per the apportionment against the vehicle B and C by a common law remedy of filing a suit and not in the same proceeding. So please, friends, have in mind, in case of composite negligence, the option is given to the claimant to sue any one of the tortfeasor, any one of the wrongdoer. It is not compulsory to sue all the vehicles. It is for one insurance company to pay the entire compensation, and the compensation apportioned has to be recovered by the insurance company against the insurer who is not made a party by filing a civil suit only. That is what the Supreme Court held in Carvernon and Kenny's case. And in case of a burden of proof, what is the degree of evidence required? Normally, the burden of proof lies on the claimants. But in case of contributory negligence and in case of composite negligence, contra evidence is to be adduced if they raise the defense of contributory or contra evidence. For example, if the insurance company raises the plea of contributory negligence, or if an insurance company raises the plea of composite negligence, they must examine either the driver of their own insurer or the IO of the FIR concerned or any other ocular or eyewitness. Without examining anybody on the side of the respondent, there can be no evidence of contributory or composite negligence. This has been held by the Supreme Court in a case called Machindranath versus Mailarappa, reported in 2008, volume 13, SEC, page 198. 2008, volume 13, SEC 198, where the evidence of the driver of the colliding vehicle is very much essential to adjudge the question of composite negligence. I got only two more topics to conclude my talk. And the fourth important facets of self-negligence. Mr. Ashok Kumar has raised a relevant question. I'll come to it when next part it is being considered. Self-negligence. This is a very important aspect where I would very regretfully say that the law is not at all understood. And one judgment of Supreme Court by 3 judges bench is highly misinterpreted, misunderstood, and not appreciated well by even by the High Courts. So I would say the fourth aspect of negligence is self-negligence. Self-negligence means in the absence of involvement of any other vehicle, the victim causing the accident by his own negligence. For example, I drive a vehicle, I dash against a compound wall, I dash against a roadside tree, or I dash against something and I fall down by capsizing vehicle. It is called self-negligence. Here, the basic rule, my learned friends may kindly understand, a self-negligent victim, or in case of fatal accident of self-negligence, there can be no claim petition under any of the provisions of the MV Act, including section 163A, because what he is going to do by filing so, he is claiming compensation against his own insurance company, which is impermissible under the Motor Vehicles Act. Friends, please understand that section 163A is not meant to enable a victim of road accident to sue for compensation against his own insurance company except under the head of personal accident coverage. Even the personal accident coverage is outside the ambit of TP claim, that is the recent judgment of Madras High Court. This is a case where the Supreme Court judgment is highly misunderstood, highly misinterpreted, and not even understood by most of the judicial officers. I would rather sorrily say that, including some of the judges of the High Court. The case that has been wrongly understood by the brethren is a case reported in 2019, volume 12 SEC, page 395. It's a case between Shivaji versus United India Insurance Company Limited. I should thank my learned senior friend, Mr. Suresh, Advocate Madurai, who is my mentor and who is an expert in the MB Act, for having given me an insight about what is the law about. See, we all know that a person who is the owner of the vehicle cannot claim compensation against their own insurance company, though he is at fault, though he is self-negligent. For example, a person who borrows the vehicle, for example, a friend of mine borrows my vehicle. When he drives the vehicle, the law considers that he is deemed to be the owner of the vehicle. He steps into my shoes. In such case, in two cases, the Supreme Court held. One case is called Ningamma, another case is called Ram Kiladi. Ningamma is reported in 2009, volume 13 Supreme Court cases, page 710. Ningamma, 2009, volume 13 Supreme Court cases, page 710. And Ram Kiladi, 2020, 1 TNMAC, page 1 Supreme Court. In these two cases, Supreme Court has categorically held that an owner of the vehicle cannot maintain claim petition against his own insurance company. This has been held by the Supreme Court in umpteen number of cases. There can be no liability unless he happened to be a third party. It is called the Rajini Devi's case. There is Sunita Rathi's case. There is Jerome's case. There is Jumma Zaha's case, where the Supreme Court has held that a person who is the owner of the vehicle cannot claim compensation against his own insurance company. The same logic applies to person who borrows the vehicle. In Shivaji's case, what happened? Justice Chandrachud of the Supreme Court, sitting with two other judges, has given a finding that the claim petition in this case is maintainable. In this judgment of Supreme Court of India, in Shivaji's case, the facts of the case and the factors leading to accident were not discussed. This is taken undue advantage by some of the advocates on the part of the claimant to state that the Supreme Court has given a seal of approval, thereby enabling the borrowers to maintain a claim petition against this one company. If the case before the High Court between Shivaji and United India Insurance Company at the Karnataka High Court is gone through, we can easily find out it is a case of collision of two vehicles. In the Shivaji's case before the tribunal, there was a collision of two vehicles. Shivaji was found to be negligent. Shivaji was accused of negligence. Both the courts found that Shivaji was negligent. So Shivaji's claim petition under section 163A was held not maintainable. When the matter came to Supreme Court, the Supreme Court has correctly held that between the two vehicles, Shivaji is a third party for the colliding vehicle. So when section 163A is invoked, the insurance company of colliding vehicle cannot go into the question of negligence. So the claim petition of Shivaji is maintainable against the colliding vehicle. The Supreme Court in Shivaji's case did not hold that Shivaji's case is maintainable against his own insurance company. This part of the story is not taken into account because the Shivaji's judgment by Supreme Court has not given the facts of the case. But friends, please go through the judgment of Kannada High Court in Shivaji's case, where you can find that the finding of negligence in Shivaji's case is on his part. It is a claim under section 163A. The Supreme Court held that he can claim compensation against the colliding vehicle, not his own insurance company, because a claim by the wrongdoer is maintainable under section 163A of the Motor Vehicles Act. Then finally, let me go to the miscellaneous aspects of the negligence. With that, I would close my deliberation. Number one is res ipsa loquitur. We know the thing itself speaks. There is a case of Supreme Court in 1977, reported in 1977 to SEC, page 745, Pushpa Bhai Purushottam's case, one of the landmark case, where the Supreme Court has held by following the jurisprudential principles of Solomon, stating that the maxim res ipsa loquitur applies whenever it is so improbable, that such an accident would have happened. Such an accident would have happened without the negligence of the defendant or the respondent, and a judge can find without further decision. If a court is able to find that there was a negligence on the part of the respondent without any doubt, without any evidence, it is called res ipsa loquitur. For example, after the rough sketch, if it is found that the vehicle has gone to the other side of the road and the vehicle which is supposed to be on the left side has gone to the right side and meets with an accident, it is called res ipsa loquitur. The thing itself speaks for itself. This is applicable in motor accident cases in case of evidence available to show that no further proof is required. Halsbury's Laws of England says when the event charged as negligence tells its own story of negligence on part of the respondent, the burden of proving it is on the respondent only. It is not the burden of the claimant. It is called a res ipsa loquitur. The judgment of Supreme Court of India in res ipsa loquitur is Sharla Dikshit case reported in 1996, volume 3 SEC, page 179. 1996, volume 3 SEC, page 179, Sharla Dikshit versus Balwant Yadav. And there is one more case by the Supreme Court in the year 2003. 2003, volume 9 SEC, page 208, Thakur Singh versus State of Punjab. 1996, 3 SEC 179, Sharla Dikshit, 2003, 9 SEC, page 208. These are the classic case of what is called res ipsa loquitur. And there is one more thing called the doctrine of last opportunity. This is discussed by the Supreme Court in Municipal Corporation of Greater Bombay versus Lakshman Iyer, AR 2003 Supreme Court 4182, where the Supreme Court has explained the concept of doctrine of last opportunity. In simple word, I can describe it as follows. In case of composite negligence or in case of contributory negligence, whichever party who could have avoided the consequence of others' negligence would be liable for the accident. Between the two persons, who was having the chance of avoiding the accident lastly is called doctrine of last opportunity. This is also held by the Supreme Court in 2003, 482 in Municipal Corporation Bombay. And finally, two important aspects I want to say before conclusion. Whether evidence given by a person who is not informant to the police, who is not the complainant, who merely accompanies the victim to the accident, can give evidence of negligence, can it be relevant? The Supreme Court held in Parameshwari versus Amarchand, reported in 2011, volume 11 SEC, 635, stating that a witness who was not related to the victim, who was not the informant, who helps him to be admitted in the hospital, gives evidence that is very much relevant, it is to be relied upon. And before finally, I got one more thing to say, the two things, whether there can be contributory negligence by children. The Supreme Court says for the children below the age of 15, there can be no contributory negligence. Case law is Sudhir Kumar Rana. Sudhir Kumar Rana reported in 2008, volume 12 SEC, page 436. Sudhir Kumar Rana, 2008, volume 12 SEC, page 436. And last but not the least, one judgment, whether a claimant who relies upon a part of the FIR can ignore the remaining part of the FIR. This often happens in the tribunals. For example, for one particular aspect, the claimant may rely upon the FIR. Remaining part, he would say the FIR is not binding on. The Supreme Court says no. In a case between Oriental versus Premlata Shukla, reported in 2007, 13 SEC, page 476, where the Supreme Court held a claimant who relies upon one part of FIR cannot ignore or discredit other part of the same FIR. And finally, once again I said, a driving license by a minor without license cannot amount to contribute to negligence unless he is proved to be the person who has caused the accident. This could be the broad spectrum of negligence, because negligence is not the topic which is defined by the statute. This is only governed by judge-made law. So with the available time limit, I think I was able to throw some limelight on the various aspects of negligence called self-negligence, composite negligence, contributory negligence, and negligence implicitor, and various phases of negligence. With that, I conclude my elaboration. Thanks and Jai Hind.
Thank you, Mr. Srinivas. The insights, as usual, they were spot on. The different issues in a different way have been explained in a very elucidative manner. First, I will take a question from the Facebook. It says by Shankar Das, Whether premium paid under the IMT 29. What is the rule position where the deceased is the employee of an insured?
I'm not able to follow the question. What is the?
Whether premium, when premium has been paid under the IMT 29, what is
Okay.
the rule position where the deceased is the employee of an insured?
The company is liable, and I'll cover it when I come to the question of payment of compensation quantum in the next series. In next series, I'll be covering the IMT most.
D. Raghavan, accidents happen due to bad speed breakers. Who is responsible? Due to high beam lights within the city limit, who is responsible?
Always the driver, and in case of any laxity or dereliction on the part of the state, we can file the case against the state also, but not by MCOP, by filing a writ petition. The state is liable in case of poorly maintained road or improper speed breakers laid, where the state government can be held liable. But in case of high beam, only the vehicle which is coming on the other side can be held liable, not our own drivers.
This is by Murugan. What is negligence implicitor?
Negligence implicit means the person who is the claimant is not negligent. Only the driver who is the first respondent driver is liable, which is called the negligence implicitor. There was no negligence on my part. It was only on the part of the other side. For example, driver of the first respondent. It is called the negligence implicitor.
This is by Umesh Gandhi. Would the family members of the insured in the car or two-wheelers be considered as a gratuitous passenger or a third party?
In case of Act policy, they are gratuitous passenger. In case of comprehensive policy, they are called occupants of the private vehicle, companies liable. This is held by the Supreme Court in Tilak Singh's case. I think I dealt with the last occasion, probably he has not seen it. In case of Act policy, an occupant of the private vehicle and pillion rider are not covered. They are gratuitous passenger. If the policy is a comprehensive policy, section 2 of the policy says that occupants are third parties and the insurance company is liable.
This is by Amit Singla. He says, Supreme Court dismissed SLP when 3 passengers riding on two-wheelers were sitting in between. Composite negligence was not appreciated. What is your take?
That's why I say, simply because 3 persons, adult person sitting in a two-wheeler, there can be no automatic inference of negligence. There must be evidence by the insurance company stating that the 3 persons or the driver of the two-wheeler caused the accident. Unless there is evidence that the two-wheeler rider caused the accident, simply because 3 adult persons were occupying the two-wheeler, there can be no automatic inference of negligence. It is a matter of evidence. This is V. Ramasubramanian Madras High Court has given a judgment recently.
This is, if two-wheelers met an accident, no policy of two-wheelers, but owner of vehicle have some property. If injured person can the injured person attach the property before the judgment? Any citation?
After getting a judgment, he can attach the property. The judgment of Supreme Court in 2005 called Oriental versus Nanjappa. You can see it. Oriental Insurance versus Nanjappa is the judgment guiding factor for recovery of the award amount against the owner of the vehicle by any mode known to law. As I said in the last occasion, it all depends on local law. In case of Tamil Nadu permits EP as a civil court decree. It depends on the local rules of the tribunal concerned. But to my knowledge, it can be proceeded against the owner of the vehicle under the Revenue Recovery Act also. It is permissible. You can proceed against other vehicles of the owner.
This is, as you said, that the res ispa loquitur, things speak for itself. Defendant has the burden of proof. So to influence / manipulate the proof or proving the criminal as innocent, one can change the place of things as they were misplaced while accident takes place. Then how can
100% it is possible. That's why I say now of late tribunals have stopped applying receipts or register and last opportunity because lot of frauds taking place. So now, to my little knowledge, courts are not applying receipts or register and last opportunity because of every possible manipulation by the police people or by the claimants. So in academic interest, I don't find any recent judgment following receipts or register and doctrine of last opportunity. It's very rare.
this is by, he says if professionals travel together to a work, will there be a gratuitous passenger or what?
I don't follow the question, sir, if you don't mind, please.
He says, though he's specifically written advocates, if advocates travel together to a district court for work, whether they will be defined as a gratuitous passenger?
It all depends the vehicle and the policy. For example, in my car, if I take my advocate clerk and my junior, if the policy is the comprehensive policy, they are all occupants of the private vehicle, the company is liable. But if my policy is act policy means they are gratuitous passenger. That's why I request all the advocates here, please to see that whenever you have a vehicle and have a policy, please avoid taking act policies. Act policy is a curse. Rather, I would rather, this is Kribahana Madras High Court has openly said that act policy should be abolished. Because the premium is very low, some people go for act policy. Act policy has got limited liability. To cover the occupants of the private vehicle, let us better take comprehensive policy. So if I take my clerk in my vehicle, unless it is a comprehensive policy, I am running a risk. If it is a comprehensive policy, the company is liable.
I think what happens is whenever one takes the insurance, one only compares the rate. Then he doesn't understand the
Exactly, sir.
what are
Exactly.
the nitty-gritties of the same.
Exactly, sir. It is all the mischief.
Neither one understands as such. Maybe a lawyer could understand. The ordinary person would believe that they are charging 10,000, he's charging 9,000. I should go for the 9,000.
Exactly, exactly. And the agents play a lot of role in misinterpreting the positions of the policy. And that's why I say unless we have a direct contact with the company officials, the agents do a lot of mischief. So it is not the premium that counts. It is the benefit we are going to have at the end of the session is going to count.
Yes. We the questions on WhatsApp as well as on the Facebook we have taken. And thank you, Mr. Srinivas, for giving the insights, the part 2 of the webinar, part 2 in the series. I think one. Tomorrow, in pursuit to our webinars, we would be having, since we all talk of that there's a lot of stress, etc. Therefore, tomorrow we will be having a webinar by Rajyogini B.K. Usha, that is from Brahmakumaris. She's a senior Rajyog teacher of an international motivation speaker, plus management speaker and TV personality. So do join us tomorrow at 4 p.m. On the topic stress management, because we all keep on reading and otherwise also that there's a lot of stress. I'm happy that Mr. Raghavan feels that there is no stress, and that's a very heartening to see that expression. So thank you to all the participants who have been watching us on the Facebook as well as on this platform, and those who will ultimately watch us on the YouTube channel of Beyond Law CLC, where this webinar will be uploaded, and the previous webinars have also been uploaded.
Mr. Vikas, there should be no stress on the part of the advocate, and there should be no negligence on their part also.
That's true. That is ultimately one should understand how to manage the things. That's paramount.
Exactly.
Because if one is stress is invariably created because of the own thought process. Though yes, there are sometimes circumstances beyond the control of someone, but still that is again a management. Everything is a management. Court management is a management. Understanding of the law is management. So even the stress, how it can be managed and how it can be minimized is also management. So thank you to all the participants once again. Namaskar. And now we can all start our professional this thing. We have learned the nuances and over to the professional work. And tomorrow at 4 p.m. we will connect. Thank you everyone. Stay safe, stay blessed. Namaskar.
Thank you. Jai Hind.